Hi, I'm Sharon Abaud, immigration attorney in the area of Los Angeles, California. Today I was asked a really good question that I want to share with all of you. The question is, do I qualify to file for a work permit while my green card is pending? Green card and permanent residency are the same thing, so I will be using the words interchangeably, but know that I'm talking about the same thing. The answer to this question is yes and no. It all depends on how you're immigrating to the U.S., how you plan on becoming a resident. Are you filing for what's called adjustment of status? That means that you are staying in the U.S., you are filing in the U.S., you're going to your interview in the U.S. You don't have to leave the U.S. to become a resident. If that's how you're immigrating, then yes, you qualify to get a work permit. This means that once you have your work permit, it does take about 90 days to get your work permit once you file. Lately, it's been taking a little longer. But the good news is that while you're waiting for your green card, and the wait's getting increasingly longer, but while you're waiting for your interview or your green card, you get this work permit. And this work permit allows you to have a Social Security. And the Social Security number that you get does stay the same once you become a resident. So you can start building some credit. And you also get Social Security credits that also will remain once you become a resident. So that's the perk of that. If, however, you are immigrating by having to travel abroad to either your country of birth or country of citizenship, you're having to go to a U.S. embassy or consular office abroad, then the answer is no, you cannot get a work permit while your case is pending, unfortunately. That means you'll have to wait until you re-enter the U.S. as a resident to start working. You're probably asking, how do I know if I qualify to apply for residency in the U.S.? Because it sounds a lot better. It has some more benefits. Well, there are three basic ways. And by the way, I'm basing this on family-based petitions right now. So if you have a family-based petition and you had 245I from the past, most people have 245I. No, they have it. But in case you don't, 245I means you had a petition, whether it be employment-based or family-based, filed for you prior to April 30th, 2001. This can also, you might have 245I if someone filed for your mom or your dad or your ex-wife or ex-husband, or if you have an immediate family member who had 245I, you might have 245I too. So it'd be wise to consult with an immigration attorney to find out if you have 245I, because that is a big golden ticket. Another way to immigrate in the U.S. is through what's called the lawful entry. Your last entry was lawful, and so that may qualify you. And also, if you have family members that are or were in the U.S. military, who were honorably discharged if they're not currently in the military. So those are three basic ways. I am providing an informational packet in the very near future about this, so I don't want to go into any more depth about that. But that's that. I also want to say something about consular processing. If you're traveling abroad to go to your interview, be careful and don't just go because you think it's the right thing. Make sure you consult with someone, because a lot of people do plan on going for 2-3 weeks to go to the interview, and they end up getting stuck out there because they didn't know that by leaving the U.S. they actually triggered a 10-year bar, and now they have to ask for a waiver if they even qualify for one. So just be mindful of that. But if you do immigrate in the U.S., to end the question, then you do qualify for a work permit, and that means you can get your Social Security number and you can start working. I hope this helps. I know I probably brought up a lot of other questions. If you have any other questions about anything, I'd be happy to answer them. My name is Sharon Abaud, immigration attorney in the area of Los Angeles, California. Thank you.